All right. I've got at the top of the hour here, welcome everyone for joining us for this webinar today. My name's Chad, and I'm going to let our two speakers introduce themselves in just a second, but I wanted to go over a couple of housekeeping items. During this webinar, if you need to ask a question, please use the chat feature, which is found on the right side of your screen. And this is just a reminder that the webinar is being recorded. We will provide a link to this presentation from our website. So I'm going to go ahead and turn it over to our two speakers today.
Hi, this is Stacia Burke, and I am the MDT Project Coordinator with the Commission on Child Abuse, Rape, and Domestic Violence, and that means Multi-disciplinary Team Coordinator. In Arkansas, the MDTs are specific to child abuse cases. Prior to being the MDT coordinator, I've been here 6 years. I just had my 6-year anniversary a couple of days ago. I was a full-time attorney ad litem in the dependency neglect cases where I represented kids in court. I did that for almost 9 years before I came over here. And the commission, we're a governor's commission, and we have commissioners that oversee us, and there is an attorney ad litem seat on the commission, and I was appointed by the governor's office while I was an attorney ad litem to sit on the commission, and I became the chairman of the Child Abuse Committee. During that time, there was some legislation passed in 2007 that we will talk about a little bit in this presentation, which created state funding for MDTs and CACs and brought those under the commission. And through that legislation, I was able to come over into the position that I have now.
Okay, and I'm Elizabeth Waldrum, and I work with Stacia at the Commission, and my title is the Child Safety Center Project Coordinator, and I assist in the funding process for child advocacy centers in Arkansas, as well as development of new centers. And I'm an LCSW, and I've been in the social work field for about 10 years, and previous to my time at the Commission, I spent most of my time with in day treatment facilities with preschoolers, in group therapy settings, and other various types of settings with kids that had behavioral issues and abuse allegations and so forth. So we're going to go ahead and get started. Is that right, Chad? Okay. We're going to go ahead and get started. First, I just wanted to say that we have a lot of content on the slides that we're going to show you, well, on some of them. And the reason for that is that we wanted to quote the law and make sure that you had an accurate representation of what the law says. We're not going to read everything on the slides, but we did want you to have, complete information. Also, we are going to stop periodically to answer questions that you have. So while we're talking, if you have a question, I would encourage you to go ahead and type it in. That way we can, when we do stop for questions, we can have the questions already there. If there comes a time where there's a question that we feel might be best answered individually, our contact information is at the end of the presentation, and you guys are more than welcome to contact us at any time. This is our first webinar. So bear with us. We're going to do our best, and we're talking to a computer, which is a little bit awkward for us, but we're going to do our best. But please ask questions as they come up. We're going to give a lot of information today, and even after the presentation, you're welcome to contact us as well. Okay, so the goals for our presentation today, the first one is to understand how the child abuse investigative system operates in Arkansas. And really, we could spend hours talking about how the system operates in Arkansas, so we're going to give a very short description of how it's supposed to work. And the reason for that is we want to make sure that you understand, because it's such a large system and there's so many people that are involved, it's important to understand how many, the extent of the roles that folks have, because when we talk about the roles of therapists, we want you to have a broad perspective on the system as a whole, so that you can really understand how you fit in and how you can help reduce trauma to kids within the system. Secondly, we want to help you understand the different roles within the multidisciplinary team structure. And third, to understand the mental health professional's role within the system. Many of you probably already participate on MDTs, so you may already understand a little bit about how that works, but for those of you that don't, it'll be new and beneficial information. And then, obviously, to recognize how to minimize trauma to the child victim throughout the investigation and therapeutic process. Okay, so what we first want to discuss is the multidisciplinary team and child advocacy center model. This is a diagram that at the top there you'll see the logo for the Children's Advocacy Centers of Arkansas. They didn't create this diagram, but they do use it to help assist in describing what the purpose of the multidisciplinary team and child advocacy center model is. So I want you to think about, in your own experience with the child welfare system, if this is a familiar diagram to you. And we'll just briefly go through part of it. So at the top, you'll see a child. Her name's Robin. She's age 5. She tells her teacher that she's being hurt at home. She goes to school, and so at school, her teacher talks to her. Then the teacher decides the principal needs to talk to her, the school nurse, and then the school nurse also examines her. So after all of that, the school calls the hotline and the police. The police officer talks to Robin, and then the police officer takes Robin to the hospital where the nurse, the social worker, another doctor all talk to Robin and examine her. And then the detective is assigned and brings Robin to another place where a nurse, a social worker, and a doctor want to talk with her. And then a child protection investigator wants to talk to Robin. And then, of course, the lawyer needs to talk to Robin as well. And then afterwards, then you as a mental health professional come in and need to talk to Robin. And so at that point, you can understand how Robin would be frustrated that she has now talked to 15 people and told these very personal details of her story. And so I'm sure this is familiar to most of you. This is what used to happen when kids disclose abuse, and we recognize that this type of model still happens in some areas of our state. We're trying to get away from the model. It's not, evidence and experience has shown that this type of model is not beneficial to the child, it's not beneficial to the investigation, and it's definitely not beneficial to the family. So we're trying to move away from that. Okay, so in the beginning, we want to explain how this model is changing. So in 1985, Congressman Bud Kramer from Alabama had a case where he had a little girl who he is a prosecutor, and throughout the case, he realized that this little girl had, was Robin in the last diagram, basically, and had talked with numerous individuals. And by the end, when they got to trial, and when he interacted with the little girl, realized the toll that speaking with all of those professionals had taken on the child. And so he decided that, there has to be a better way to protect children from being re-traumatized in the system. So he decided there needed to be a multidisciplinary team coordinated response to child abuse allegations, and out of that developed the Child Advocacy Center model. And we'll talk about that a little bit later. But that is a model where all of the professionals come together in one setting where the child only has to ideally speak with one, possibly two team members. And so the first CAC was developed in Huntsville, Alabama, and it's called the National Children's Advocacy Center.
So as a result of this national movement, Arkansas has also recognized the need to follow the MDT and CAC model. As I previously mentioned, there was some legislation passed in 2007, and that was Act 703, where the MDTs and CACs became legally recognized and funded through our agency, the Commission on Child Abuse, Rape, and Domestic Violence. Both the CAC purpose, which was identified in Act 703, and the MDT purpose, which was developed by a statewide group here at the Commission, recognize the need to have a system where we reduce trauma to the children and the families that are going through this investigative process. One of the charges of the Commission was to come up with a more unified MDT structure and system. So through that, we look to the national model for MDTs and CACs. There's a national organization called the National Children's Alliance that accredits child advocacy centers, and they have requirements of MDTs, including who should be on an MDT. So we look to that model to come up with our MDT structure. And in Arkansas, we also added juvenile court because they play such an integral part of the system, and they usually have a lot of history on the families that we come into contact with in these cases. This is a map of the current MDT system, and the goal through this legislation is to have an MDT in every county. So hopefully there is an MDT in your county, and as a TFCBT therapist, you should be on the MDT in your area.
Okay. So this is what should happen today when kids need help after they've made an allegation of abuse. And this looks very different than the previous diagram that we discussed. So look at the bottom, on the bottom left corner where it says start here. Robin tells her teacher that she's being hurt at home. Ideally, the hotline's called at that point, and then Robin goes to the CAC with her mom. The investigator meets her at the CAC, and all of the other professionals that need to be there, such as the nurse that will do her sexual assault exam, the therapist is there, as well as any other individuals that need to view the forensic interview. And so this is ideally the goal. This is what we're shooting for in Arkansas. We want to minimize the number of interviews that children have to participate in. And this CAC model has been shown that research shows that there's greater satisfaction with caregivers, there's less trauma to the child, and there's greater coordination and collaboration between multidisciplinary team agencies. So this is the ideal model that we have right now that we're working off of. So in Arkansas, we have 13 CACs. Nationally, there are over 750 child advocacy centers. In Arkansas, we have 13. We're working on a 14th right now in Clark County. So as you can see from the map, the counties that have a little plus sign in them are the locations of the 13 CACs. And then this map was developed again by the CAC chapter here in Arkansas in an effort to cover the state if investigators have questions about where the nearest CAC is or which CAC is prepared to respond if the investigator calls. This is the service area map that was developed. The service area map is not mandatory. Investigators can take kids to whatever CAC they prefer. We just prefer that they take them to a CAC. Okay, so I think we're going to stop here for questions. If you guys have questions, let's take this time on the material we've discussed, and if you have questions, we'll give you a little bit of time to type those in so we can go ahead and respond to those.
And for those just joining, to ask a question, there's a little chat feature. Looks like a bubble icon on the right side of your screen. So.
Okay. Well, if you think of questions, feel free to continue to type those in as we're talking. But I think we're going to go ahead and continue.
One thing that we do want to reiterate is to let you know that the child welfare system is a huge system, and to let you know that we do recognize that children can experience trauma after a report of abuse or neglect is made, and to let you know that we that work in this system recognize that, and that is always at the forefront of our minds, because we're doing this every day. So what we want to do now is kind of back up to the beginning and let you know from the reporting process through the investigation where children may encounter trauma, and efforts that we have taken, and I say we, those professionals in the system, have taken to try to recognize points where they can experience trauma and to reduce trauma during this process. Many abused children are known to a number of adults. Mandated reporters fail to report 60% of the cases where abuse is suspected. So that is definitely, before the call is made, that is definitely a point where children have already experienced trauma, and if reports aren't made, they can continue to experience trauma at the hands of the abuser. An individual is listed as a mandated reporter in the Child Maltreatment Code and shall immediately notify the Child Abuse Hotline if you have reasonable cause to suspect that a child has been subjected to maltreatment, or if you observe a child being maltreated. Okay, we have a question that relates to the previous section, so we will go ahead and take that question. There may be numerous mental health professionals in one area, or that could be on one multidisciplinary team. So there are coordinators that are assigned to each MDT, and there's a core group. And so how we decide whether or not a mental health professional is right for an MDT, first of all, if they're associated with a child advocacy center, then usually within that advocacy center they may designate who would be the one assigned to the MDT. Also, a mental health professional should be treating kids that are abused or neglected in order to be on an MDT. Usually that's going to be a team decision, but each team can have more than one mental health professional, and so that's going to be a county-by-county team decision.
We have one more question. I think the second question is regarding the hotline, and we'll address that coming up in this next section. If we don't, we'll go back and try to clarify.
So we've taken part of the list from the mandated reporter law, and we want to point out that this is a partial list, and the code site for mandated reporters is there. And then Chad is also going to send out the complete law to you as well. But what we've included here are areas where you may either be encountering mandated reporters, or you yourself may have dual roles and be a mandated reporter in these other areas. So you can see on this part of the list is the mental health professional. Also, an employee of a child advocacy center or child safety center is on here, and many of you are either employed by an advocacy center or a contract employee of an advocacy center. work in a community-based victim service or mental health agency, you're a mandated reporter, or if you're a sexual abuse advocate or volunteer, you're also a mandated reporter. So because the law requires people to report suspected abuse, there are also laws developed to protect you as well. So if you have a privilege with a client or a contract with a client or an employment agency, that does not prevent you from reporting child maltreatment. Also, an employer or a supervisor cannot prohibit you as a mandated reporter from directly reporting child maltreatment, so they cannot put in policies or procedures that where an agency has one person that manages all of the reports and that they're the ones that call it in. Also, they cannot require an employee or volunteer to notify the employer first or request permission or some type of documentation before you make the report.
Okay, so as you know, kids will report allegations of abuse to you as therapists. Obviously, you spend a lot of time developing rapport with children in your practice, and we know that kids talk to people who they feel safe with, and oftentimes that person will be you. So you are an important person in this whole MDT approach to child abuse investigations, and how you handle the disclosure or the allegation is going to be extremely important to the rest of the system. So managing disclosures, we hear oftentimes that, well, we went ahead and did our own internal investigation and determined that wasn't true, that the allegation wasn't true, or that the child, was lying, or whatever the case may be. And really, that really destroys the investigation in general, as well as, the child came to you because they felt safe talking with you, and so it's so important that you limit any internal dialogue or investigation at all. Really, that shouldn't be happening at all. There are professionals within the MDT, DHS workers, Crimes Against Children Division, local law enforcement. That is their job to investigate. So it is not your job to do any type of investigating when a child discloses abuse to you. And this should be really reflected in your policies and procedures at your agency. It's going to be important that everybody's on the same page as far as, what do we do when a child discloses abuse to us? And is that written in your policies and procedures? And if it's not, that might be important to review and to modify, just because, it's going to be important for your agency as well as, reducing trauma for that child. Secondly, verifying information. Again, this kind of goes along with the internal investigation. There's no need for you to verify information that the child is saying. If they use a name that you're not familiar with, there's no need for you to try to find out if that person actually does live in the home or doesn't live in the home. That's not your job, again. That is going to be up to the investigator. And additionally, protecting the confidentiality, that you have in your relationship with the child is going to be very important as well. Again, the child chose you for a reason, and if they know that once they tell you, you're going to go asking questions and telling other people that, they probably won't tell you again. Additionally, verifying information with the caregiver is never appropriate. We've had situations where, with good intentions, people will try to verify information with the caregiver and inform the caregiver that the child has disclosed certain statements, and the caregiver will take their frustrations out on the child. They will tip off the offender, and so it's just not a good idea to be in the practice of doing that. Third, making false promises to the child is never appropriate. It's difficult to hear some of the information that children tell us sometimes. But we need to be very conscious of the words that we're using with them. It's not going to be okay to tell them that, you know, you're never going to have to see this person again, they're going to get in trouble and be arrested. You know, those are things that we don't know if those are going to happen. We of course hope they do, but we never want to reassure a child of things that we're not sure about ourselves. So be aware of doing that. And really, it's really important to assure the child that the child is not in trouble with you, that you're glad that they came and told you and that they felt safe enough to talk with you and that they're not in trouble. Okay, so some detailed information about contacting the hotline. This is written in the law as well, specifically for mandated reporters, of which you all are. The idea of calling the hotline report in versus faxing the hotline report. Faxing reports should really only be done in non-emergency situations, and when you fax a report, you should be getting a fax back from the hotline eventually, saying whether or not the allegation was accepted for, or the report was accepted for investigation, and if it wasn't accepted, why was it not accepted? Additionally, we want you to understand that you can call, when you call in a report, you can be anonymous when you call in a report. When you fax in a report, you have to include your name and phone number. So faxed reports are not anonymous. It's always best, in our opinion, to call in a report. In most situations, the reports that are called in are going to be received at a faster rate than the faxed reports. And so just be aware of that. And also, we'll go back to internal policies again, and we're going to address this several times in the presentation, that, you know, it may be important to include in your internal policies at your agency, you know, the procedures for calling a report in versus faxing a report in. I think sometimes people think that, oh, we can just fax the report in and we've satisfied our requirement as reporters. And sometimes that's true, but if it's an emergency, then it really needs to be called in. An emergency is a relative term that, you know, within your agency needs to really be defined.
So after you call the hotline, that is a system that is operated by the Arkansas State Police, and you're calling the child maltreatment hotline. So those calls go to the civil investigators that are investigating these cases for child maltreatment purposes. And there's a protocol that they follow, and the hotline follows that protocol and knows whether or not they assign the case to the Crimes Against Children Division located within the state police or to DHS. The investigative agency then, under the law, is supposed to immediately notify local law enforcement of all reports of severe maltreatment. There is, in the Child Maltreatment Act, there are different categories of maltreatment. A priority one is the most serious and most severe maltreatment. That is going to be most of your sexual abuse cases, your severe physical abuse cases, and then there's other categories of cases that fall within that, like threat of harm, drugs, and other allegations, abandonment, things like that. So those agencies receive the reports, then should be immediately notifying law enforcement. Another way these cases can be initiated is if a victim is taken to a police department or police are called to a scene, and then law enforcement may call the hotline. So that would be a way that law enforcement knows about a case before the hotline is made. But the hotline does not have any procedures in place where they directly notify law enforcement of all these cases themselves. That goes through the maltreatment, the civil investigators. The law also requires the civil maltreatment investigators to notify prosecutors of these cases. Ideally, the team members will then coordinate their investigation and notify CAC that they need to bring a child in for services. There was actually a law passed in 2011 that states that when the CAC, when available and appropriate during the course of one of these investigations, that the child should be taken to the CAC for the forensic services. So at that point, under the CAC and MDT model that we explained earlier, the maltreatment side, the civil investigators, and the criminal side should come together before the child is interviewed. Hopefully, they are all trained in the MDT process and know what their roles and responsibilities are. They take the child to the CAC for the forensic interview. Now there are circumstances where the child may not or cannot be interviewed at an advocacy center. So regardless of where the child is being interviewed, the MDT members should be implementing best practices throughout the investigation and should still be coordinating that interview with the maltreatment and the criminal side together, interviewing the child at the same time under a forensic interviewing model. It's also important for the child to receive an appropriate medical exam, whether that's for sexual abuse or physical abuse or some other type of medical maltreatment. The civil investigators and criminal investigators are also trained in how to conduct offender interviews. That should be coordinated. And also collecting corroborating evidence and interviewing witnesses. All of these elements should be coordinated in every single child maltreatment investigation. Child witnesses and collaterals, siblings, can also be interviewed at the CAC. So hopefully any child interviews will be taking place at a CAC. Because of these investigations and the nature of them and the nature of child advocacy centers, there are laws that have been put into place to keep these records confidential. Some of you may have heard several years ago about the Tony Alamo case. Those children on that compound were interviewed at a child advocacy center, and through the criminal process, the offenders were able to obtain the DVDs of the child interviews. They chose to place some of those interviews on the internet, on websites, and sent a transcript of an interview to the paper, to the Democrat Gazette, who published it. So out of these examples, we have placed laws that keep these records confidential. So at each of those steps, the coordinated investigative services and how to reduce. So after investigative process, and this also, some of these services could happen during the investigative process, how to reduce trauma to the child and implement advocacy, force mental health services, and any other services the child or family may need, whether or not that's, the kids coming into foster care and providing parenting classes, anger management, some type of sex offender treatment, medical treatment. All of that should be coordinated and clearly defined so as to reduce confusion and trauma to the child.
Okay, guys, so this is another questions. We'll wait a few seconds to see if any questions come in. So if you have questions about coordinated investigations, mandated reporting, that's the section that we just covered.
And the question that's hanging out there is actually going to be covered in the next section, so we'll wait until that section to talk about the question that's already posed to us.
Okay, well, we're going to move to the next slide.
What we want to, again, recognize and reiterate is that this is a huge, complex system with different sides to it. There are many different players. There's the civil players, and they are all, each agency is looking for different information. Sorry, we're looking at a question that just came in. So we have a question about what is your advice about contacting a parent to let them know a hotline call has been placed and why? Within the child maltreatment protocol, the civil investigators have to notify the parent of a child within their investigation, and they have certain time frames on when they do things. So it shouldn't be the mandated reporter that's notifying a parent about their child disclosing abuse and you making a hotline report. Unless you coordinate that with the investigator, Elizabeth mentioned that there have been times when parents have received that information and either, acted adversely to the child or tipped off an offender that a call has been made to the hotline. So our advice would be not to notify parents unless there's some type of safety issue. So let's say a child is in your office and discloses abuse by the caregiver that's out in the waiting room, then you have a safety issue at that point, and you may need to coordinate, if it's accepted, coordinate with law enforcement or the investigator that hopefully, if it's an emergency situation, you'll be telling the hotline, we don't feel comfortable letting this child leave with this caregiver, and here's why. So hopefully that would initiate a more immediate response to wherever you are with the child. Now, we do have, I know that there's instances, for example, where in the ER or during an exam, for example, in a medical issue where Children's Hospital tells the parents, they call the hotline and it says, we've called the hotline and we're not letting the child leave with you. Examples like that where they do disclose that they've called the hotline and why. But as a general rule, that should not be happening. So the child welfare system is a huge system. We have the criminal side, the maltreatment side, and each agency, each investigator, each interviewer, medical professional that's within the system has a role and a responsibility in reducing trauma to the kids that are going through the system. And if they are in the system, then they should be specially trained professionals. So some examples of instances where professionals may inflict trauma to kids are, let's say an investigator is interviewing a child at their house, it's an out-of-home offender, and can't get to an advocacy center for whatever reason, so they decide to interview the child in the child's room because in their mind and assessment, the child's room is a child-friendly place. Only they come to find out that the abuse happened in the child's room. Well, that re-traumatizes the child. Another way we can traumatize children in this process, or things that have happened before, are taking children to providers who are not trained. So if a child is seen within their community by a pediatrician for a sex abuse allegation, or taken to an ER without specially trained, sane professionals, then we can get misinformation on a sex abuse exam, and the child may, first of all, be subjected to an inappropriate type of exam, the family and the child can be given misinformation, such as, we do see evidence of abuse here, when in most cases there is, most sexual exams are going to be normal, and that causes stress and, anxiety for the child and the family. And then once the investigators recognize that that was an inappropriate exam, they're going to have to take the child for an appropriate exam, so then the child is being examined twice in a case. If investigators or interviewers don't follow protocols, let's say they have been trained, but they don't follow the appropriate protocols, that can also cause trauma to kids. So if we have an investigator or an interviewer that's in a hurry and doesn't take the time to follow their forensic interviewing protocol, we can have non-disclosures or not complete information. So we had a child who was in a situation where an investigator came to their school to interview them and told the child, I have 20 minutes to talk to you before I have to be somewhere else. And the child decided that she was not going to talk to that investigator that day, and in the meantime was abused again. Also, you as mental health providers, if you are trained in forensic interviewing and decide to conduct an interview of the child, if they make a disclosure and try to present that information to an investigator, that counts for investigative purposes, and the investigator would have to interview the child again. A second interview could cause trauma to the child, and they may not understand why they have to talk to the investigator when they've already told a therapist, somebody that's safe for them, all this information. Some good examples of reducing trauma to kids are whenever law enforcement and prosecutors' offices have specially trained investigators and prosecutors, and who are assigned to specific units, such as the juvenile unit, and focus on these and best practices, and are very, very versed in the law and confident in taking these cases. There's police departments that regularly use advocacy centers and have specially trained detectives that assist on these cases. They listen to the interviews, get the information they need, and some of them have two detectives at each interview so that one can stay there with the child and family while the other one goes out and starts collecting evidence, makes contact with prosecutors, makes contact with judges to get warrants, maybe dispatches a patrol car to sit on a place where where the incident happened, or to sit on a suspect so that they can immediately begin the investigation. When you have specially trained people in place, then we can get better information more efficiently. So there was a case where a child disclosed that her dad pees in her pee. Well, the child was taken to an advocacy center with a forensic interviewer, and the disclosure came out that the child would use the bathroom in the toilet, and then the dad would use the bathroom where she had already used the bathroom. If people aren't trained and don't know child development and the appropriate questions to ask, you can see where that situation could have turned out in a different way.
Okay. So specifically for your role as a therapist, we wanted to give you some key tools and steps to help you recognize how you can reduce trauma to the child throughout this system. So first, it's really important, again, as we kind of briefly discussed earlier, to talk about, or to think about identifying an appropriate place and just monitor your surroundings when a child is trying to tell you something. Obviously, if you work in a school and you're a school-based therapist, you know, talking with the child at the back of their classroom is probably not appropriate. And so, you know, making sure that you take the child to a neutral setting that they're comfortable in is going to be important. Also, again, as we've said several times, just respecting confidentiality. Be aware of who's around. Be aware of where the child feels comfortable. Be aware of who, you know, the potential interruptions you might have if and when you're talking to a child. And then, you know, there's no need to notify anyone else of what you're doing. Again, the law specifies that you do not need to notify or get permission from anyone to make a hotline call. So if you're in a school, we don't need to talk with the nurse or the teacher or the principal. If you have a group therapy setting, you know, my advice on a group therapy setting would be if a child discloses something in a group therapy setting, obviously they feel comfortable and safe enough to do that. So I would let them say what they're going to say and then maybe move on with the group. And after the group, take the child into your office or some other neutral, comfortable setting that the child feels safe in and, you know, gather other information that you might need to call the hotline at that time. It's important to recognize that, you know, again, the child chose you specifically to disclose this information to. So you need to minimize who you're speaking with, you know, about the allegations. Other people don't need to know. And, you know, if children know that every time they talk with you about something, other people are going to know about it, or you're going to talk to them in the middle of the hallway while everybody's going to lunch or something like that, you know, kids can easily get embarrassed and feel more shame and more guilt about telling, because it took them, as you know, as therapists, it takes people a while to disclose information like that. So it's really important that you pay attention to your response as the person who's hearing the information. Okay, and we also wanted to distinguish between the difference between forensic interviewing versus a therapy session. So that we've put the definition of a forensic interview here so you can kind of see that, you know, it's a lengthy definition that really specifies that this is a very particular way of speaking with children that a trained forensic interviewer only can do. So if you are, as Stacia said, you know, if you are trained as a forensic interviewer and you're also a therapist, that's going to probably present some challenges for you because you're really going to need to pay attention to the difference between conducting a forensic interview during a therapy session and actually doing a therapy session. And so that's important to do. We wanted to distinguish, too, between an outcry and a trauma narrative. So as TSCBT therapists, you have an opportunity to proceed to the trauma narrative portion of the therapy model, and that's going to be where the child may give you details about their abuse. But the outcry is the initial disclosure that the child gives, and that's really what we're referring to here. Before investigations have been done, before the hotline's been contacted, that's what we consider to be an outcry. So pay attention to the fact, you know, is it a new disclosure or is it new to you? If it's new to you, then that's all we need to know. We don't need, you know, you as a therapist don't need to figure out if this is a new disclosure. If it's new to you and you suspect that the child's been abused, then you call the hotline. If, you know, oftentimes children are going to be seeing you as a therapist because of a previous report of abuse, and if that's the case, then you're going to know that up front. You're going to be able to gather that information in the assessment phase, and so this would not be a new report of abuse to you. And so in that case, my recommendation would be if you know that it's already been investigated and you've gathered that information in the assessment and that's the reason why they're seeing you for therapy, I don't see a need to report that. If while in therapy they disclose new information to you that you were unaware of, then that may be an instance where you need to report it. So if a child discloses new information to you, whether or not you know if it's a new allegation that's been investigated or not, it's going to be important for you to collect this basic information. So the name of the victim, which you're already going to have because they're a client of yours. The name of the alleged offender, you may not know their name, but you may know the relationship to the child, the dad, the boyfriend, the neighbor down the street. But the child may give you a name as well. If they don't give you a name, that's okay. The nature of the maltreatment, which is probably how you know that there's abuse that may have occurred because they're going to tell you something that happened. And then the location of the incident, which is not as important, but if they tell you that, then obviously that's going to be beneficial information. So that's the information that would be valuable to have when you call the hotline. Now, at a minimum, the hotline only needs the name of the alleged victim and how to make contact with them and whatever type of abuse is suspected. So at a very bare minimum, that's what they need to know. And so that just shows that there is no need for you as a therapist to probe for more information or to ask detailed questions. You just need that basic information, and you're probably going to know that already. A couple of questions that you can ask the child during a therapy session that might be helpful, but also doesn't interfere with the forensic interview that will take place is if the child discloses something to you, you can say, what do you want to tell me about that? And so that's an open-ended question, and you would just gather information. There doesn't need to be questions that, you interject in the middle of that. You just let the child say what they want to say, and then you as a therapist are going to have to find a way to continue the therapy session without asking specific questions that a forensic interviewer would ask. And also you can ask another open-ended question such as, have you ever told anybody else about this abuse? And so that may be a way to know if anybody else is aware of it. And they may say, yeah, I told that DHS lady, so then you would kind of know what's happened in the past. So, and also, when you call the hotline, they're going to have a lot of questions that they're going to have to ask you just because that's their job. They have to, ask for a lot of information. And what you can tell them is, I gathered the minimum amount of information I could get without doing an interview. And that's okay. You can say that to them. And as therapists, I think that that's important to sort of, to the last bullet point there, to recognize where your boundaries are. You are great at what you do, and your role in the MDT process is a mental health role. It's not an investigative role. And so you have to recognize that. And all of this information, however you choose to develop it within your agency, is going to be beneficial to put in your internal procedures, as we've discussed previously.
So what we would like for you to be able to take away from this is to know that the child maltreatment system involves many people and many different agencies, that we as a state recognize this and also as a nation recognize this and have implemented policies, procedures, laws in order to try to have everybody working together in order to reduce trauma to these children. And we have implemented best practices and standards and training so that the professionals working within the system work together and are specially trained in their specific areas. You, as therapists, can also help reduce trauma to the child by appropriately managing your disclosures, calling the hotline when necessary, and developing internal procedures that support and encourage the protection of children, and while maintaining the integrity of the investigation. I think that that's an important statement to make, that you recognize that you need to minimize maybe getting into investigative type issues. Then the most important role that you can play is providing the CFCBT or other type of therapy and continuing to support that child and help them heal.
And when in doubt, we always just say call the hotline. So if you're not sure if you should call the hotline, I would just say go ahead and call in most cases. And then it's their job to decide if that's something that needs to be investigated. Okay, so if you have any other questions, I think our time's about up. We have maybe like 4 minutes left that we can answer questions that you have, so feel free to go ahead and type those in. We are going to leave you with a couple of helpful links. Our website, that's where we work, the Commission on Child Abuse, Rape, and Domestic Violence. It has our information about our programs, and it actually has the map of, with your TFCBT trained therapist on there, and the CAC service map. And then the National Children's Alliance, which is the accrediting body for child advocacy centers. And then Stacia and I's email and our phone number. And we get calls and emails all the time, so please feel free to contact us anytime. And we'll just go ahead and wait a couple of minutes for questions if you have any. And I think I answered the question about that we had earlier about, okay, about if you should hotline an incident if it's already been hotlined and the investigators met with the victim and family. But if the person who wrote that doesn't think it was addressed, please let me know, and we'll be happy to go back to that.
Also, we let Chad, because neither of us had presented a PowerPoint before, we let Chad experiment with the chat during the presentation. So at some points we may have paused during our presentation and you heard silence, we were reading questions. So feel free to give us feedback on the process of this webinar as well.
And as always, I'll send out a copy of the PowerPoint and as well as a complete list of who is a mandated reporter. We're just kind of going through questions, making sure we've answered all the questions that have come up, and I think we have. We'll stay on for another minute or so, and for those of you who've joined, I just want to, say thank you for taking an hour out of your Friday. Hope everyone has a great weekend, and we don't have an exact date for the next webinar, but just be looking for an email for January 2014 webinar. So thank you to everyone. Again, we'll still be here for 30 more seconds to take any last-second questions. All right, well, if anyone does have any last-second questions, you can email me or Stacia, and Elizabeth's contact information is there as well. So everyone take care.